What do you call a 6-week period in which you and a handful of very, very recent acquaintances get drunk every day at lunch, sleep through the afternoon, sell weed to each other, smoke weed with each other, and whip out a few bags of cocaine to snort when the time feels right? For a group of 12 people in Florida in 1987, they would call it jury duty. That's right. In an affidavit filed later, a juror described himself as, quote, flying high during the entire trial. Another juror stated that he felt like, quote, the jury was just one big party. This is the story of a very wild, very bad drunk jury that caused so much trouble their case made it all the way to the Supreme Court with one simple question. Does a jury's verdict still stand when they were, for all intents and purposes, hammered the entire time? The Supreme Court said yes. It stands. And to this day, that rule is still the rule. Other cases of jury misconduct over the years have gotten crazier and crazier, including in one case where a jury convicted a man of double homicide by consulting a Ouija board. I wish I was joking. We are breaking down Tanner versus United States and going over jury misconduct, why we should care about it, and why the rule is what it is. We are going to wade through all of these messes and more in today's episode of the Rebuttal podcast. My name is Reb Maisel. I'm once again your host. And because I do my research so thoroughly and so well, I am recording this after a night of having a little bit too much fun. Legal fun. Okay, legal fun. I'm 29, so that means that having too much fun is like having 3 beers after 10 p.m., right? Not feeling great the next day. That was me, is me right now. I wanted to get into the mindset, the headspace of what the jury was feeling for 6 fucking weeks. So don't say I don't commit to the bit for y'all for this damn podcast. Thank you. The facts of this case, I personally don't think can be understood properly unless you have the summary at the beginning. So here is this beautiful, gorgeous summary, okay? And then we're going to get into the nitty gritty, the knitter gritter, so that you can enjoy it. Great, amazing. This case involves a company called Seminole Electric Cooperative Incorporated that we're going to call Seminole, okay? It is a Florida corporation owned and operated by 11 rural electrical distribution cooperatives. They generate and transmit energy, electrical energy to the co-ops, okay? Seminole does. Seminole, this cooperative, obtained a bank loan, a federal bank loan, to fund construction of a power plant near Palatka, Florida. This loan was over $1 billion, okay, that it borrowed from the federal government. As part of this loan and as part of the plant's construction, an access road would be built. Okay, 51-mile long access road, a big fucking access road. All right. As part of this loan and the construction of the plant, okay, a federal agency called the Rural Electrification Association, the REA, guaranteed Seminole's loan and had the rights, okay, in return to supervise the project, which included supervising and approving who worked on it, what contractors were happening with it, what materials were being used, et cetera, et cetera. All right. Federal oversight over the $1 billion loan that we just gave you, all right, to basically be able to control this project without actually being the boots on the ground. Okay, you get it. William Conover, one of our co-defendants, was Seminole's procurement manager, and he, at this time, did not understand that you cannot fuck with the federal government in this way. No, you cannot. Okay? No. Stop it. Enough. No, you can't. He steered, pushed contracts for fill materials for this 51-mile long access road to his friend, Anthony Tanner, the other co-defendant, who illegally compensated Conover in cash and cash equivalent services, quote unquote, whatever that means, in return for steering Tanner the contracts. Amazing. Now let's get into the nitty gritty of the facts that the Supreme Court was focused on. Under the loan contract for this billion-dollar plant that was going to be built, The REA could supervise the construction and equipment of the electrical system and inspect, examine, and test all work and materials relating to the construction project. REA bulletins and REA memoranda required Seminole to obtain REA approval before letting out certain contracts and required certain bidding procedures to be used depending on the type of contract. So you can't just like pick who you think is the best and let it happen. No, they wanted to have a bidding process for certain situations, for certain materials, for certain, obviously, sub projects and things. People who are in construction know it gets fucking complicated. And to override that, to circumvent that, is a no-go. Okay, it's a no-go. Don't do it. The plans for this coal-powered electrical plant in Palatka, Florida required the construction of the 51-mile access road. The road required materials that would support heavy trucks and resist flooding. And in March 1981, 2 years after construction, Conover was informed that Seminole's current construction contractor was having difficulty obtaining enough suitable fill material for the road. Now, remember, Conover is the Seminole procurement manager guy. The contractor indicated that it had not attempted to locate alternative fill materials and that the contract price would have to be increased in order for him to complete the road, and so that contract was terminated. Okay. Following a Seminole meeting at which Conover was informed of the difficulty in building the patrol road, Conover called a friend, Anthony R. Tanner. Okay. Don't work with your friends. Tanner owned a lime rock mine, and the two discussed the possibility of using lime rock and lime rock overburden as an alternative fill material. The issue with this is that lime rock is soft. Okay. It's pretty soft for the shit that they need to do here. So, from jump, they're not using their brains, their noggins. They're already, to even say that, oh, what? I was just, trying to find a solution. Babe's this was not a solution. Okay, this was not a solution. It was not. Apparently, I mean, I'll get to it, but it was, the Florida climate and the soil and the foundation, everything. They were like, why the fuck would you use that material? And they did. They tried and they did. Seminole acquired lime rock overburden from Tanner on an interim basis so that the road construction could continue while bids were solicited for the remainder of the project. Seminole called for bids on a contract for provision of fill materials as well as a contract for building the road. Both contracts were to be paid with loan money guaranteed by the REA, the federal government, okay? And the contract for building the road required the REA's approval, period. The final specifications for the two contracts, which were prepared by Conover's procurement department, were favorable to Tanner's company in several respects. Hint, hint, nudge, nudge, okay? They're fudging the numbers here to get the REA to choose Tanner as opposed to anyone else more suited for the trabajo, for the job, which is what I like to call fraud. You're defrauding the federal govy. Is that going to work out for you? It is not. Tanner was awarded both contracts on May 14th, 1981. The fill material contract paid approximately $1.4 million, and the road construction contract paid approximately $500,000. In 1981, I don't know how much that is, but it's a lot. All right, it's a lot. Several problems developed after Tanner began working on the road. There was a dispute as to whether Seminole or Tanner were required to maintain access roads leading to the patrol road. Conover advised Seminole that the contract was ambiguous and that Seminole should pay for maintenance of the access road. So, Tanner's already causing problems. This is my thing. If you're going to defraud and you, get away with it, okay, at this juncture, you got the two contracts, okay? You're thinking, let's go, let's do this. You should just put your head down and do the fucking contracts, right? Now you're bitching about the maintaining the access road and conditions, and you're claiming the contract's ambiguous. Baby, the contract was that was you. You got that. You got it, right? You got the contract. Have your cake and eat it before I kill you. You got the cake and now you're like, whoa, I want to heat it up. You can't heat it up. That's what you ordered, okay? That is the benefit that you get. Shut your mouth, sit down, and close your mouth, better yet. But, of course, Tanner didn't, okay? Tanner did not. He's bitching and moaning at Seminole about ambiguities in the contract and all that bullshit. So, ultimately, Seminole was like, okay, fine, I guess we'll pay for this fucking access road that you claim you need in order to build the main 51-mile road, whatever the fuck, okay? Later, the REA complained that the bond provided by Tanner was not from a bonding company approved by the Treasury Department. In two letters to another bonding company in July 1981, Conover represented the construction on the patrol road to be considerably more advanced than it was at the time. So, Already it smells fishy to the federal govy, okay? Post securing these contracts, they're like, wait. And it was also discovered, which I think was the nail in the coffin, to be honest, for like literally jumpstarting an entire federal investigation, was that during the course of construction, the lime rock, which weakens when wet in Florida, it weakens when wet. And you're in Florida. That's where you're building this. That's where you're. Listen, the jokes write themselves. Okay, the jokes fucking write themselves. Could not be used in areas subject to flooding in Florida. For these, for those areas, Tanner's company provided and spread sand at a higher price than the sand provided and spread by the first contractor. So they're just like upping the price on shit. This is not good criminal work, okay? And look, I'm not down for anyone to be violating federal law and defrauding anybody, of course not, committing crimes, if you will. But I can always at least respect the hustle in the game when you're like, oh, like almost, right? Almost had it. You did everything right until like one Johnny Jamoke fucked it up for you. No, like both of these guys are the Johnny Jamokes. Just flagrant fouls everywhere, every which way, to the point where if I were their defense attorney, I would look them dead in the eyes and go, Lime Rock, Florida, perfect. So we're going to plead down. There was obviously heaps of evidence as well that came out later that at the time Conover had called Tanner about using lime rock as the fucking fill material for this patrol road, all right? Tanner and Conover were friends and they had engaged in several business deals together. And through the course of this constructing the road, just there had been a lot of money exchanging hands, okay? That was very clearly like under the table, like you scratch my back, I scratch yours type thing, okay? Obvious paper trails. I mean, look, they did not write the book on being a criminal. I'll tell you that much. If they did, don't read it. In June 1981, before the patrol road was finished, representatives of one of the members of the Seminole Cooperative requested that Seminole end all business relations with Tanner. Seminole initiated an internal investigation, after which Seminole suspended and later demoted Conover for violations of the company's conflict of interest policies. You can get demoted, baby. That's just fine. But when the federal authorities start knocking on your door, it's time to piss your pants a little bit. Time to lawyer up, for sure, for sure. In June 1983, this investigation wrapped up with Conover and Tanner being indicted, okay, on charges, felonies, prison time. Okay, prison time potential. But I'm sure that Conover and Tanner would both have loved to at least get this thing over with like, oh, I don't know, maybe one trial. Oh no, this whole thing was chaos from the start, not just because of the drunk, smashing wild, the jury gone wild situation. A 6-week trial first, okay, their first trial resulted in a hung jury and a mistrial was declared. So they re-indicted them, okay, round 2. The first count in this re-indictment alleging conspiracy to defraud the United States in violation of federal law, and the second through 5th counts alleged separate instances of mail fraud in violation of federal law. Conover was convicted on all counts. Tanner was convicted on all but count 3. The day before both defendants were scheduled to be sentenced, Tanner's attorney filed a motion in which Conover subsequently joined, seeking continuance of the sentencing date and permission to interview jurors, an evidentiary hearing, and a new trial. Okay, so like big motion, all right? New trial? You're kidding. That's a big thing to ask for. What is your grounds? Well, according to an affidavit accompanying the motion, Tanner's attorney had received an unsolicited telephone call from one of the trial jurors named Vera Aspule. Juror Aspule informed Tanner's attorney that several of the jurors consumed alcohol during the lunch breaks at various times throughout the trial, causing them to sleep through the afternoons. The district court continued the sentencing date, saying, okay, that's wild. Maybe let's, you know what I mean? Like, let's like pause for a second and figure this out. All right. They then ordered the parties to file memoranda and heard argument on the motion to interview jurors. The district court, the trial judge, concluded that juror testimony on intoxication was inadmissible under Federal Rule of Evidence 605B to impeach the jury's verdict. So essentially like throw it out, okay, and have a new trial about it. The district court invited petitioners, the defendants, to call any non-juror witnesses, such as courtroom personnel, in support of the motion for a new trial. And they did, okay? The court was basically relying on this rule of evidence 606B to say, hey, like, we can't have juror testimony, and I'll explain it to you later, okay, why exactly that is, after a verdict's already been rendered to basically overturn a verdict. Like, that's not we're not going to do that. Do you have anyone else? And they were like, yeah, actually we do. I mean, courtroom personnel, right? Like bailiffs, like clerks, everything, okay? And even one of the defense attorneys took the stand to basically say, yes, they were hammered drunk. Yes, they were fucking partying. Yes, it was a shit show. Tanner's counsel, when he took the stand, testified that he had observed one of the jurors in a, quote, sort of giggly mood at one point during the trial, but did not bring this to anyone's attention at the time. Okay, like giggly mood. I mean, connecting the fact that they were hammered, sure, but like she was just like really giggly. I'm sure it was a shit show in there, though. I'm sure people were acting weird, but like say something during the trial, not after the verdict. Fuck. Earlier in the hearing, the judge referred to a conversation between defense counsel and the judge during the trial on the possibility that jurors were sometimes falling asleep, okay? Because they were hitting it early, apparently, at 9 a.m., 10 a.m., okay? Typically, like, you will bring the jury in probably around 9 or 10 a.m., like, at the latest, if you're running a pretty strict, like, jury schedule. Sometimes it's, like, right at 8 a.m. on the dot. Like, you don't even have, chat between the judge and counsel for very long. You're just like, all right, like, bring them in. Bring them in, and they're in. Okay, they're in and sat. So to give you an idea, all right, by the afternoon, they were done. Like, they were done so. They were PTFO, pass the fuck out. And this is a 6-week fucking trial. Okay, 6 weeks. I swear to God, there's another juror who comes forward and confirms this. The entire 6 weeks, like no breaks, no sleep, no stop. Bus, club, another club, another club, another hit of beer, another shot of liquor, another line of Coke, another blunt. I'm sure that jury room smelled crazy as hell, if we're being serious, okay? If we're being really dead serious. And I'm sure there's even more drama about like people maybe like having canoodling. We don't know. We don't know, okay? But at least 2 jurors were like, I am not about this, even though they definitely partook. Partook? We'll see. During an exchange between the judge and counsel during trial, when the defense counsel was like, hey, like jurors are falling asleep, what's going on? Okay, because mind you, and this will be stressed like later, you'll learn. During trial is when you want to mention this shit. Like during trial, especially if you're noticing it, like that's when you want to be like, hi, no, like that fool smells like a liquor cabinet and he's passed out, mouth open, catching flies. We need to stop this right now, okay? And one of the defense attorneys tried to do this. And during that exchange, the judge advised counsel to immediately inform the court if they observed jurors being inattentive and suggested measures the judge would take if he were so informed. The judge noticed that, okay, maybe some of them are inattentive. I will keep an eye on it. And then it wasn't mentioned again. Keep mentioning it, please. The judge also observed that in the past, courtroom employees had alerted him to problems with the jury. They were tattled on, okay? Quote, nothing was brought to my attention in this case about anyone appearing to be intoxicated, the judge said, but he added, I saw nothing that suggested they were, okay? According to the judge. And of course, he's going to try to CYA anyway, right? Because if he was like, yeah, I noticed them being hammered drunk, I mean, it's your job to control the courtroom, like figure it out. You know what I mean? Like, this is not chill. But whatever. Following this hearing, the trial judge, okay, the district court filed an order denying this motion for a hearing and denying their motion for a new trial, saying, I find no reason to have a hearing to interview jurors. Like, there's no reason for it. There's just simply no reason. Denied. Okay. And they appealed immediately. Defense counsel appealed both motions to the 11th Circuit appellate court. Okay. Circuit court. While the appeal of the denial of those motions was pending, okay, in the 11th Circuit, Tanner's attorney received an unsolicited visit at his residence at his home from a second juror, Daniel Hardy, which is wild, okay? And on that basis, basically what they talked about, what Daniel told him, he filed a second completely new motion for a new trial and a second motion for a hearing to interview jurors, okay? Saying, hi, there's even more additional evidence that shit was bonkers back there in the jury room. Let's hear it. In Tanner's interview with Daniel Hardy, he stated that he felt, quote, like the jury was on one big party. Hardy indicated that 7 of the jurors drank alcohol during the noon recess. 4 jurors, including Hardy, okay, including Daniel, the one who's the whistleblower here, the second whistleblower, consumed between them, quote, a pitcher to 3 pitchers of beer during various recesses. Of the 3 other jurors who were alleged to have consumed alcohol, Hardy stated that on several occasions, he observed 2 jurors having 1 or 2 mixed drinks during the lunch recess, and 1 other juror who was also the foreperson, okay, the one who's like the one in charge of the jury, okay, like you all elect a person to be the foreperson and be like the head, the speaker for the jury, okay, it's like a class president, but for the fucking jury. Yeah, the fucking foreperson had a liter of wine on each of those 3 occasions. A liter of wine. Juror Hardy also stated that he and 3 other jurors smoked weed quite regularly during the trial. Moreover, Hardy stated that during the trial he observed 1 juror ingest cocaine 5 times and another juror ingest cocaine 2 or 3 times. And mind you, this is just what Hardy saw and is willing to say, right? So they're doing it openly in front of that one guy 2-3 times. I'm sure it was a lot more than that, okay? A lot more than that. One juror sold a quarter pound of marijuana in 1987, okay? It's illegal everywhere. One juror sold a quarter pound of marijuana to another juror during the trial and took marijuana, cocaine, and drug paraphernalia into the courthouse. It's not funny. It's kind of funny. Hardy noted that some of the jurors were falling asleep during the trial and that one of the jurors described himself to Hardy as, quote, flying. Hardy stated that before he visited Tanner's attorney at his residence, no one had contacted him concerning the jury's conduct, and Hardy had not been offered anything in return for his statement. Hardy said that he came forward to, quote, clear my conscience and, quote, because I felt that the people on the jury didn't have no business being on the jury. I felt that Mr. Tanner should have a better opportunity to get somebody that would review the facts right, end quote, which is admirable, right? He had some integrity here, okay? He was going to own up to some shit and, not for the sake of getting people in trouble, but for the sake of having the 2 defendants, have a fair trial. But, I mean, and I'm not going to say in this jury's defense, because of course that's wild and none of you should do this. All of you should be jazzed about jury duty because you're doing your civic duty, okay? And we need some fucking sane people on the fucking juries, okay? I'm looking at you. But you shouldn't be jazzed about jury duty for the wrong reasons. Like this, you know what I mean? You shouldn't be fingers crossing hoping that Daniel the drug dealer is gonna be in your lineup. Okay? Maybe do partake in these things some other way. Okay? Some other way in some other venue for sure. But I will say in their defense that the summary I gave you of these facts, right, of like mail fraud, whatever, right, they're charged like mail fraud and conspiracy to defraud the federal government, all the shit. The density of the facts of this fucking case and like the contracts and the fucking road and the fucking lime shit that wasn't working and the soft and the this, it is like explained in the worst way of all time. I read it 4 times and was like, wait, what the fuck? And no. So like they weren't getting, for 6 fucking weeks of this trial, for 6 weeks, guys, they're listening to the dullest testimony of people going on and on to like lay the foundation for what Lime Rock is and for what this contract is and the federal government and what this agency does. I would also need a drink. I think I wouldn't have one, but I would need one. Unfortunately, the majority of these jurors caved into the need, the desire, and said, we're going to bring it right into the courthouse. Goodbye. These renewed motions were denied just like last time. They were appealed just like last time. The cases were consolidated. The 11th Circuit denied, okay, affirmed the convictions and denied these motions, and it finally went up to the U.S. Supreme Court, okay? They filed a petition for writ of certiorari, and the Supreme Court said, yes, we'll take it. Thank you so much. This is a great issue. Maybe we should clear it. When this was pending before the U.S. Supreme Court, a lot of lawyers and legal scholars thought, wow, this is a very extreme example of the application of this particular rule, Rule 606 of the Federal Rules of Evidence, that could absolutely add a new exception to this rule. That would be great because the rule as it stands doesn't necessarily include this as something that was contemplated a little, okay? But let's hear it, okay? This is what the rule says before I get into the court opinion, all right? This is the rule that has to be invoked in this in relation to questioning a verdict, okay? A verdict meaning like it's already happened. This doesn't have to do, okay? Asterisk here so that all y'all know, this does not have to do with jury incompetence or misconduct discovered during the trial. Okay, like pre-verdict, right? During the trial. This is post, okay? They deliberated and they rendered a verdict post-verdict, okay? This is the rule that applies. Rule 606B says, during an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberations, the effect of anything on that juror's or another juror's vote, or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statement on these matters. And I'll explain to you the public policy reasoning behind that rule. Okay, I will. So don't freak out. Don't hold your breath. Keep breathing. I'll get into it. There are exceptions to this general rule, and those are that a juror may testify about whether 1, extraneous prejudicial information was improperly brought to the jury's attention, 2, an outside influence was improperly brought to bear on any juror, or 3, a mistake was made in entering the verdict on the verdict form. Very narrow exceptions here. The argument that Tanner's defense counsel made was that, hey, this is an outside influence, meaning like the drinking and the drugs and the partying was the outside influence that was improperly brought to bear on all the jurors. Okay. They assert that contrary to the holdings of the district court and the court of appeals, juror testimony on ingestion of drugs or alcohol during the trial is not barred by Federal Rule of Evidence 606B, which is what I just read to you. Moreover, defendants argue that whether or not authorized by Rule 606B, an evidentiary hearing including juror testimony on drug and alcohol use is compelled by their Sixth Amendment right to trial by a competent jury. Emphasis on competent, okay? Which is indeed correct. This is a direct quote from a United States Supreme Court case prior to when Tanner was decided, and it's still good law. It's still a good quote. Quote, one touchstone of a fair trial is an impartial trier of fact, a jury capable and willing to decide the case solely on the evidence before it. End quote. Do you see how this can fuck up the Sixth Amendment right to a competent jury in your trial when people are hammered and ripping lines in the back room, liters of wine and mixed drinks, the foreperson is boozing, okay? Drug, alcohol, we're having drug deals go on, okay, in the room. Shit is exchanging hands. I mean, it's a great argument to make, okay? Like, is this really a fair fucking trial here? Competent jury, emphasis on competent? Well, let's hear it. Let's see, okay? Let's see it. Let's understand it. This Supreme Court opinion was written by Sandra Day O'Connor, which is pretty recent in her tenure as a Supreme Court justice, the first woman on the Supreme Court. So 2 parts of this opinion were unanimous, okay? All the justices said, yes, we join. But then 2 other parts of the opinion were a 5-4 split, okay? 4 justices dissented and 5 were down for the get down. I will read parts of the dissent, but most of it relates to, drug and alcohol abuse during the trial and whether or not that qualifies. This is what the majority opinion said. By the beginning of this century, if not earlier, the near universal and firmly established common law rule in the United States flatly prohibited the admission of juror testimony to impeach a jury verdict. Exceptions to the common law rule were recognized only in situations in which quote, extraneous influence was alleged to have affected the jury. In a case called Maddox, this court held admissible the testimony of jurors describing how they heard and read prejudicial information not admitted into evidence. The court allowed jury testimony on influence by outsiders in Parker versus Gladden and Remmer versus U.S., where a bailiff's comments on the defendant were chatted at, okay, to the jurors, which is outside influence. And then in Remmer, a bribe was offered to a juror, okay? So those are all situations that the Supreme Court has already said, yes, those qualify as the exceptions that a juror is allowed to testify on after the verdict, okay? What about the drug and alcohol use? Well, let's see. In situations that did not fall into this exception for external influence, however, the court adhered to the common law rule against admitting juror testimony to impeach a verdict. Substantial policy considerations support the common law rule against the admission of jury testimony to impeach a verdict. As early as 1915, this Supreme Court explained the necessity of shielding jury deliberations from public scrutiny. Quote, "Let it once be established that verdicts solemnly made and publicly returned into court can be attacked and set aside on the testimony of those who took part in their publication, and all verdicts could be, and many would be, followed by an inquiry in the hope of discovering something which might invalidate that finding. Jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts which might establish misconduct sufficient to set aside a verdict. If evidence thus secured could be thus used, the result would be to make what was intended to be a private deliberation the constant subject of public investigation, to the destruction of all frankness and freedom of discussion and conference. The Supreme Court's holdings requiring an evidentiary hearing where extrinsic influence or relationships have tainted the deliberations do not detract from, but rather harmonize with, this weighty government interest in insulating the jury's deliberative process. The court's statement in Remmer that the, quote, integrity of jury proceedings must not be jeopardized by unauthorized invasions could also be applied to the inquiry petitioners seek to make into the internal processes of the jury, aka in this case right here in Tanner. There is little doubt that post-verdict investigation into juror misconduct would in some instances lead to the invalidation of verdicts reached after irresponsible or improper jury behavior. It is not at all clear, however, that the jury system could survive such efforts to perfect it. Allegations of juror misconduct, incompetency, or inattentiveness, raised for the first time days, weeks, or months after the verdict, seriously disrupt the finality of the process. Moreover, full and frank discussion in the jury room, jurors' willingness to return an unpopular verdict, and the community's trust in a system that relies on the decisions of lay people would all be undermined by a barrage of post-verdict scrutiny of juror conduct. Federal Rule of Evidence 606B, which I read to you earlier, is grounded in the common law rule against admission of jury testimony to impeach a verdict and the exception for juror testimony relating to extraneous influences. Petitioners, meaning the defendants in this case, have presented no argument that Rule 606B is inapplicable to the juror affidavits and the further inquiry they sought in this case. And, in fact, there appears to be virtually no support for such a proposition. Oof, already. When you read that as an attorney, you're like, it's done. It's over. Rather, petitioners argue that substance abuse constitutes an improper outside influence, quote unquote, about which jurors may testify under Rule 606B because an outside influence is one of the exceptions. In our view, the language of the rule cannot easily be stretched to cover this circumstance, however. However severe their effect and improper their use, drugs or alcohol voluntarily ingested by a juror seems no more an outside influence than a virus, poorly prepared food, or a lack of sleep. It's a bold statement. That's a bold comment. In any case, whatever ambiguity might linger in the language of Rule 606B as applied to juror intoxication is resolved by the legislative history of the rule. The House Judiciary Committee that passed the rule described the effect of the version of Rule 606B transmitted by the court as follows, quote, as proposed by the court, Rule 606B limited testimony by a juror in the course of an inquiry into the validity of a verdict or indictment. He could testify as to the influence of extraneous prejudicial information brought to the court's attention, aka a radio newscast or a newspaper account, or an outside influence which improperly had been brought to bear upon a juror, for example, a threat to the safety of a member of his family. But he could not testify as to other irregularities which occurred in the jury room. Under this formulation, a quotient verdict could not be attacked through the testimony of juror, nor could a juror testify to the drunken condition of a fellow juror, which so disabled him that he could not participate in the juror's deliberations, quote unquote. In 1973, the House committee literally put that as an example in their commentary on the rule. So, like, fuck. Really? But fuck. Permitting an individual to attack a jury verdict based upon the jury's internal deliberations has long been recognized as unwise by the Supreme Court. As it stands, then, the rule would permit harassment of former jurors by losing parties, as well as the possible exploitation of disgruntled or otherwise badly motivated ex jurors. Public policy requires a finality to litigation, Sandra Day O'Connor says, and common fairness requires that absolute privacy be preserved for jurors to engage in the full and free debate necessary to the attainment of just verdicts. Jurors will not be able to function effectively if their deliberations are to be scrutinized in post trial litigation. In the interest of protecting the jury system and the citizens who make it work, Rule 606 should not permit any inquiry into the internal deliberations of the jurors. Finally, she says, even if it allowed for this, she doesn't think that the testimony they offered, these affidavits they offered, even meet the bar that would be set by that, okay? Even if Rule 606B is interpreted to retain the common law exception allowing post-verdict inquiry of juror incompetence in cases of, quote, substantial, if not wholly conclusive evidence of incompetency, this showing made by petitioners falls far short of this standard. The affidavits and testimony presented in support of the first new trial motion suggested, at worst, that several of the jurors fell asleep at times during the afternoons. The district court judge appropriately considered the fact that he had an unobstructed view of the jury and did not see any jurors sleeping. The juror affidavit submitted in support of the second new trial motion was obtained in clear violation of the district court's order and the court's local rule against juror interviews. On this basis alone, the district court would have been acting within its discretion in disregarding the affidavit. So basically, Tanner's attorney interviewing the juror, okay, in support of this new motion, the new Daniel Hardy, okay, when he like came to his office unannounced and then he ended up like transcribing the interview, that was not allowed. He couldn't do that. And he didn't anyway. So that could have been a basis for the district court to deny it, like outright without considering what was in it. But regardless, even if they had considered what was in it, in any case, although the affidavit of juror Hardy describes more dramatic instances of misconduct, Hardy's allegations of incompetence are meager. Hardy stated that the alcohol consumption he engaged in with 3 other jurors did not leave any of them intoxicated. Sure. Quote, I told the prosecutor that we would just go out and get us a pitcher of beer and drink it, but as far as us being drunk, no, we wasn't, end quote. The only allegations concerning the jurors' ability to properly consider the evidence were Hardy's observations that some jurors were falling asleep all the time during the trial and that his own reasoning ability was affected on one day of the trial. These allegations would not suffice to bring this case under the common law exception allowing post-verdict inquiry when an extremely strong showing of incompetency has been made. So the majority here isn't convinced that everyone was hammered drunk and inebriated, which I will say I don't necessarily agree with. I think what I described earlier is fair. Like, I don't think Daniel Hardy needed to necessarily say we were fucking drunk, right, to conclude that. And also, who is he to speak on other people's drunkenness? You know what I mean? But whom's to my? Anywho. As described above, long recognized and very substantial concerns support the protection of jury deliberations from intrusive inquiry. And then they turn, okay, to the other argument that the defendants make, which is their Sixth Amendment interests, all right? Their right to a competent jury, fair trial, all that, okay? All that. Sixth Amendment, very, very important, okay? So first they were arguing about 606B, and now they're like, okay, well now this is a breach of the Sixth Amendment, so you gotta give it to us. You gotta give it to us, judges. Please, please, please. Justices. Please, please, please. Petitioners' Sixth Amendment interests in an unimpaired jury, on the other hand, are protected by several aspects of the trial process. The suitability of an individual for the responsibility of jury service, of course, is examined during voir dire, which is when they question people prior to putting them on the jury, and each side is able to have some strikes, like be like, we don't want that juror, et cetera, right? The process, if you don't know, it's called voir dire, okay? So a lot of the prejudices, biases, issues that may come up from someone maybe misbehaving during trial are supposed to be weeded out during the voir dire process. But like, how much can it, you know what I mean? Like, how can you really predict? You can't. That's the uncertainty of it all, right? Moreover, during the trial, the jury is observable by the court, by counsel, and by court personnel. Moreover, jurors are observable by each other and may report inappropriate juror behavior to the court before they render a verdict, which is in italics, okay? Before. That is why I mentioned it earlier. This being, it sounds harsh, right? I'm reading this opinion and you're like, your eyes are probably wide thinking, damn, like we're fucked. Like, I don't want to go to trial ever. This jury could be doing crazy shit in the back and I don't know about whatever. But if you do find out about it, okay, and other jurors are encouraged to, like, let them know if shit happens. The attorneys can say things, if there's behavior that they've been noticing or whatnot. Court personnel, obviously, the bailiffs, like, they're in charge of watching the jury and making sure that things are going well, making sure they're not breaking the rules, doing shit that's not okay, which would include, railing lines of coke in the back room, for sure, for sure, for sure, for sure. But what's important about that is because that's before they render a verdict, right? Before. Because it is a lot easier to remedy that situation before a verdict is rendered than to wait until after and then be like, wait a minute. Which here in this case, the defendant's attorneys are claiming, well, we didn't know. We didn't know about it, but they kind of did because they were saying, oh, the jury's falling asleep this afternoon. They made comments and then you just kind of let it sit alone. Finally, after the trial, a party may seek to impeach the verdict by non-juror evidence of misconduct. Indeed, in this case, the district court held an evidentiary hearing giving petitioners ample opportunity to produce non-juror evidence supporting their allegations, aka court personnel testifying, and they didn't really testify to enough. The district court judge held, and then the Supreme Court ended up affirming. In light of these other sources of protection for petitioners' right to a competent jury, we conclude that the district court did not err in deciding, based on the inadmissibility of jury testimony and the clear insufficiency of the non-juror evidence offered by petitioners, that an additional post-verdict evidentiary hearing was unnecessary. Oof. All in all, the majority says no. The rules 606B stands. You can't have jury testimony. This isn't one of those exceptions, and you didn't put on enough evidence of non-juror testimony by other people to say that the jury was incompetent or engaged in misconduct to a degree that would support a new hearing or a new trial. No. Okay, let's hear what the dissent says. This is Justice Marshall, Justice Brennan, Justice Blackmun, and Justice Stevens join. Every criminal defendant has a constitutional right to be tried by competent jurors. This court has long recognized that due process implies a tribunal both impartial and mentally competent to afford a hearing, a jury capable and willing to decide the case solely on the evidence before it. If, as is charged, members of the defendant's jury were intoxicated as a result of their use of drugs and alcohol to the point of sleeping through material portions of the trial, the verdict in this case must be set aside. In directing district courts to ignore sworn allegations that jurors engaged in gross and debilitating misconduct, this court denigrates the precious right to a competent jury. Accordingly, I dissent from that part of the court's opinion. At the outset, it should be noted that petitioners have not asked this court to decide whether there is sufficient evidence to impeach the jury's verdict. The question before us is only whether an evidentiary hearing is required to explore allegations of juror misconduct and incompetency. As the author of today's opinion for the court has noted, a hearing permits counsel to probe the juror's memory, his reasons for acting as he did, and his understanding of the consequences of his actions. A hearing also permits the trial judge to observe the juror's demeanor under cross-examination and to evaluate his answers in light of the particular circumstances of the case. The allegations of juror misconduct in this case are profoundly disturbing. A few weeks after the verdict was returned, one of the jurors, Vera Aspel, contacted defense counsel and told him she had something she wanted to get off her conscience. She stated that at the trial, some of the male jurors were drinking every day and then slept through the afternoons. According to Aspel, another juror, Tina Franklin, could confirm these charges. So we have a new juror in the mix, okay, being thrown out there. Despite these revelations, the district court refused to hold an evidentiary hearing. Like this court, the district judge believed that Aspel's statements to defense counsel were inadmissible under Rule 606B. Several months later, Aspel's allegations were buttressed, obsessed with the 1987 language. Okay, I know that a lot of the legal law language is high, a little highbrow, right? A little inaccessible sometimes, but the word buttressed is like crazy to me. I hate it. I don't think it's good. I don't enjoy that word. Not even for the fact that some people don't, I just don't enjoy it. Okay. So several months later, Aspel's allegations were ramped up by a detailed report of rampant drug and alcohol abuse by jury members, volunteered by another juror, Daniel Hardy, who also admitted that he partook. So I feel as though like the combo of these things, you know what I mean? It's not just like the hall monitor tattling on the people who were bad. Like the guy at the party who attended and had a great time is like, hey, you got us, which I think is actually, I think evidentiary wise is more damning. But whom's to mind? In a sworn statement, Hardy indicated that 7, and 7 is in italics here. The dissent is like 7 fucking members of the goddamn jury, 7 members of the jury, including himself, regularly consumed alcohol during the noon recess. He reported that he reported that 4 male jurors shared up to 3 pitchers of beer on a daily basis. Hardy himself consumed alcohol all the time, quote unquote. The female juror selected as a foreperson was described as an alcoholic who would drink a liter of wine at lunch. Oh, more info than I gave you before. Hey, I love a new fact. The 4 male jurors did not limit themselves to alcohol, however, as we know. They smoked marijuana just about every day, quote unquote. In addition, 2 of them ingested a couple of lines of cocaine on several occasions. At times, 2 of the jurors used all 3 substances: alcohol, cocaine, and marijuana. Having this in a dissenting opinion in the Supreme Court, I'm sorry, like, it just gives me a giggle. It just gives me a laugh. Because it's just a bunch of old guys pissed off, you know what I mean? Like, can you believe just, like, clutching pearls? And, I mean, look, it's the 80s, like, shit was bumping, shit was popping, but it is funny that they have to address shit like this and judge people for this, and to be one of those people on the jury being called out by name, like, oh, the foreperson was a fucking alcoholic. I mean, goddamn. This is memorialized forever, you know? Like, it's 2024, and I'm talking about some chick's alcohol problem from 1987. A little harsh. A little harsh, but what are you gonna do? Hardy also maintained that the principal drug user, identified as John, used cocaine during breaks in the trial. Quote, I knew he had that little contraption. He was going to the bathroom and come back down sniffing like he got a cold. It's not funny. Hardy's statement supported Aspel's assessment of the impact of alcohol and drug consumption. He noted that some of the jurors, were falling asleep all the time during the trial. At least as to John, the effects of drugs and alcohol went beyond inability to stay awake at trial. Quote, John just talked about how he was flying. He was messed up. Hardy admitted that on one day during the trial, his reasoning ability was affected by his use of alcohol and weed. These allegations suggest that several of the jurors' senses were significantly dulled and distorted by drugs and alcohol. In view of these charges, Hardy's characterization of the jury as one big party is quite an understatement. End quote. Therapist. And the dissenting opinion in a footnote also accuses the majority opinion, okay, of downplaying the seriousness of this shit. They say the court's attempt to downplay the seriousness of these charges of incompetence is unconvincing. They were like, no, stop it. And they also note, quote, if only one juror were shown to be incompetent, the verdict could not stand. That's what the dissenting opinion, that's what they're standing on, okay? Despite the seriousness of these charges, the court refuses to allow petitioners an opportunity to vindicate their fundamental right to a competent jury. The court holds that petitioners are absolutely barred from exploring allegations of juror misconduct and incompetency through the only means available to them: examination of the jurors who have already voluntarily come forward. The basis for the court's ruling is the mistaken belief that juror testimony concerning drug and alcohol abuse at trial is inadmissible under Federal Rule of Evidence 606B and is contrary to the policies the rule was intended to advance. I readily acknowledge the important policy considerations supporting the common law rule against the admission of jury testimony to impeach a verdict: freedom of deliberation, finality of verdicts, and protection of jurors against harassment by dissatisfied litigants. It has been simultaneously recognized, however, this opinion kind of pops off. I don't know. I'm kind of fucking with this. I'm kind of rocking with him. I'm kind of rocking with you, Marshall. I don't know, man. It has been simultaneously recognized, however, that simply putting verdicts beyond effective reach can only promote irregularity and injustice. If the above referenced policy considerations seriously threaten the constitutional right to a trial by a fair and impartial jury, they must give way. That kind of hits. That's kind of a bar, I fear. I fear it's a bit of a bar. In this case, however, we are not faced with a conflict between the policy considerations underlying Rule 606B and petitioner's Sixth Amendment rights. Rule 606B is not applicable to juror testimony on matters unrelated to the jury's deliberations. Ooh, that's a great point. By its terms, Rule 606B renders jurors incompetent to testify only as to 3 subjects: any matter or statement occurring during deliberations, so in the back room after everything's said and done and they're ready to go, right, decide on their verdict, that's deliberations. Deliberations don't include when they're hearing everything during the trial, okay? That's not considered deliberations yet. They're not allowed to deliberate until the very end. 2, the effect of anything upon the mind or emotions of any juror as it relates to his or her assent to or dissent from the verdict. So again, deliberations. And 3, the quote, mental processes of the juror in connection with his assent to or dissent from the verdict. Again, all 3 of these are in deliberations. Even as to matters involving deliberations, the bar is not absolute. It is undisputed that Rule 606B does not exclude juror testimony as to matters occurring before or after deliberations. This dissent is hitting. It's hitting. It's hitting. But more particularly, the rule only operates to prohibit testimony as to certain conduct by the jurors, which has no verifiable manifestations. As to other matters, jurors remain competent to testify. So they're basically, the dissent is positing that this actually does not even come within the scope of Rule 606B. We shouldn't even be having this discussion. It's not about the deliberations. They could have been completely competent during deliberations. Who gives a shit? All of these allegations are related to what happened during the trial. Which is a good argument. Because petitioner's claim of juror misconduct and incompetency involves objectively verifiable conduct occurring prior to deliberations, juror testimony in support of the claims is admissible under Rule 606B. Even if I agreed with the court's expansive construction of Rule 606B, I would nonetheless find the testimony of juror intoxication admissible under the rule's outside influence exception. As a common sense matter, drugs and alcohol are outside influences on jury members. Commentators have suggested that testimony as to drug and alcohol abuse, even during deliberations, falls within this exception. The court, the majority opinion, suggests that if these are outside influences, a virus, poorly prepared food, or a lack of sleep would also qualify. But the dissent says distinguishing between a virus, for example, and a narcotic drug is a matter of line drawing. Courts are asked to make these sorts of distinctions in numerous contexts. I have no doubt they would be capable of differentiating between the intoxicants involved in this case and minor indispositions not affecting juror competency. So basically, they're like, okay, you're acting like this is going to be some bad public policy matter of like, oh, well, now, one motherfucker got food poisoning and suddenly this whole thing's going to be thrown out. Okay, I think the lower judges are going to be able to discern between a line of fucking coke up your nose in the bathroom and like someone having morning sickness. Like, can we be serious? Which is a fair point. The court assures us that petitioner's Sixth Amendment interests are adequately protected by other aspects of the trial process, voir dire, observation during trial by the court, counsel, and courtroom personnel, and observation by fellow jurors, so long as they report inappropriate juror behavior to the court before a verdict is rendered, right? Like, even the jurors, like, are held to that standard. Like, but most of them come out afterwards because they, are up at night feeling guilty, like these two people were, okay, before they came to the defense counsel. Reliance on these safeguards, the dissent says, to the exclusion of an evidentiary hearing is misguided. Voir dire cannot disclose whether a juror will choose to abuse drugs and alcohol during the trial, which I agree with. Moreover, the type of misconduct alleged here is not readily verifiable through non-jury testimony. I agree. What the jurors are doing, okay? Like, in the bathroom with each other, they're around each other all the time, even like back at their hotel room, like, how the court personnel aren't staring at them like this, like, taking notes on everything they do. Like, the point of it is that they're not doing that. What the fuck? The jurors were not supervised by courtroom personnel during the noon recess when they consumed alcoholic beverages and used drugs. Hardy reported that he and his 3 companions purposely avoided observation. Duh. They smoked weed and used cocaine first in a municipal parking garage and later down past the Hyatt Regency because it was away from everybody. So they like walked down past the hotel and shit. Finally, any reliance on observations of the court is particularly inappropriate on the facts of this case. The district court judge maintained that he had a view of the jury during trial and, quote, you might infer that if I had seen somebody sleeping, I would have done something about that. However, as the portions of the trial transcript quoted indicate, the judge had abdicated any responsibility for monitoring the jury. He stated, quote, I'm not going to take on that responsibility. I'm not going to sit here and watch. I'm not going to see. So basically the judge was like, it's not my problem. During the trial, he was like, it's not my fucking problem. When they were like, oh, they're sleeping, he was like, well, what can you do? Finally, the dissent ends with, the court acknowledges that post-verdict investigation into juror misconduct would in some instances lead to the invalidation of verdicts reached after irresponsible, or improper jury behavior, but maintains that it is not at all clear that the jury system could survive such efforts to perfect it. Wow, I can't talk. Petitioners are not asking for a perfect jury, period. They are seeking to determine whether the jury that heard their case behaved in a manner consonant with the minimum requirements of the Sixth Amendment. So, contradictory to the minimum requirements. It's okay. If we deny them this opportunity, the jury system may survive, but the constitutional guarantee on which it is based will become meaningless. I dissent. Snaps. That went hard. That went hard. That just went hard. Okay. Sometimes the dissent sucks. That one went pretty hard. Okay. So what was the aftermath of this? Okay. You would think like, oh, was it overturned? No, no, no. It's still to this dia, to this dizzy, good law. And what I read from you from 606B is very much the law. Let's hear more about it. Ever since there have been juries, there has been juror misconduct. Tanner was not the first, and it indeed was not the last. In a system without professional jurors, it is inevitable that some jurors will act unprofessionally on occasion. Varieties of juror misconduct run the gamut of human weakness, but common examples include jurors consulting non admitted evidence, newspapers in particular, investigating crime scenes on their own, lying or otherwise misleading the court during voir dire in order to be placed on a jury, committing acts of violence or other forms of unacceptable coercion in the jury room, and consuming alcohol or drugs during the course of the trial. While most jurors serve without incident, the cases cited throughout many articles and many studies done on this issue make clear that serious juror misconduct does indeed occur. As we've addressed, in response to this, courts have adopted a variety of procedural protections to be used during the course of the trial, emphasis on during the course of the trial, to counter the threat of misconduct. For example, potential jurors are questioned during voir dire, in part to root out jurors who would likely cause trouble. Some jurisdictions require judges to give jurors written instructions directing them to report misconduct. Impaneling alternate jurors also allows courts to dismiss jurors who have committed misconduct without ordering a mistrial. However, we are concerned with misconduct uncovered only after courts have entered judgment. The verdict is done. Jurors are often the sole witnesses to acts of juror misconduct, either because they themselves have committed the misconduct or because the misconduct took place in the privacy of jury deliberations. If jurors do not come forward during trial, none of the procedural protections described above can address the misconduct. Ignoring post-judgment allegations of juror misconduct implicates fairness issues and undermines the public's faith in the jury system. Tanner was ultimately the broadest interpretation of Rule 606B and by far the most restrictive allowance of juror testimony the Supreme Court had yet issued, which quickly restricted the lower courts and severely limited opportunities for jurors to testify. If alcohol and drugs were not considered outside influences, then what could possibly be considered an internal influence, okay? Despite the multitude of criticisms, concerns, and fallacies associated with the decision in Tanner, the Supreme Court recently assured its validity in their opinion of Werger versus Showers. In a 9-0 decision, okay, unanimous, 9-0, the Supreme Court ruled to not only rely on the decision of Tanner, but to use its logic to restrict the exceptions to Rule 606B even further. In that case, Gregory Werger sued Randy Showers in federal court after a motor vehicle accident resulted in Werger losing his left leg. He alleged that Showers' negligence was the cause of the accident and wished to recover for property damage, loss of enjoyment of life, permanent disability, present and future medical expenses, and prejudgment interest. After the jury ruled in favor of Showers, one of the jurors approached Werger to express her concern with a statement made by a juror named Regina Whipple, the jury foreperson, okay, who during deliberations discussed, quote, a motor vehicle collision in which her daughter was at fault for the collision and a man died, and had, quote, related that if her daughter had been sued, it would have ruined her life. This comment was made despite a lengthy probative voir dire, okay, questioning before the jury was solidified, where Whipple and every other prospective juror was specifically asked whether she would be unable to award damages for pain and suffering or for future medical expenses, or whether she thought, I don't think I could be a fair and impartial juror on this kind of case. But as we know, people are very rarely going to admit that they can't be fair. Okay? The most unfair, biased bitches in the world think that they're fair. They do. Someone else needs to come in and be like, no, you're not. Okay, no, you're not. Upon hearing this, Werger moved for a new trial, relying on the precedent of McDonough Power Equipment Incorporated versus Greenwood, which held that, quote, to obtain a new trial in such a situation, a party must first demonstrate that a juror failed to answer honestly a material question on voir dire, and then further show that a correct response would have provided a valid basis for a challenge for cause. So a challenge to that juror, okay? Basically being like, strike, no, like, get them out. The motives for concealing information may vary, but only those reasons that affect a juror's impartiality can truly be said to affect the fairness of a trial. Both the District Court and the Eighth Circuit, however, did not grant Werger a new trial, finding that Rule 606B's 606B barred, quote, any statement made or incident that occurred during the jury's deliberation. The Eighth Circuit elaborated that the exception to 606B did not apply because, quote, jurors' personal experiences do not constitute extraneous information. It is unavoidable they will bring such innate experiences into the jury room. The Supreme Court granted cert, not to refute or challenge these findings, as was the hope, but rather to affirm them. The court ultimately ruled the same way as Tanner, and that was in 2014. Let's go through a rundown of the typical remedies that can occur during a trial, okay? So you don't completely despair, right? And think that everyone's fucked always 100% of the time. So let's go through it. So some of the most common examples of juror misconduct and the typical remedy are summarized here. Absence, all right? If a juror doesn't show up, they fail to show up or they can't show up or something happened, whatever, the judge may substitute an alternate juror, okay? Like, for example, if someone failed to return after lunch, they're like, okay, someone else can come in, right? That's why we have alternates. Sleeping or being inattentive. If appropriate, the judge may substitute an alternate juror. Again, this is during trial. Reading or watching media related to the trial. When there is a substantial reason to fear that the jury has become aware of improper or prejudicial matters, an inquiry by the court is required and a mistrial or seating of alternate jurors may be warranted if the defendant's right to a fair trial would otherwise be violated. So it could either mean mistrial or just replace the juror if it was isolated to one or a few. Failure to disclose during voir dire. Okay, if they lied like a rug during the voir dire questioning process. If a juror's lack of candor is discovered before the jury is impaneled, the court may allow the parties to ask additional questions and exercise challenges. If it comes out later, the party asking for a mistrial or a new trial must show that an effort was made to draw out the information, the juror intentionally withheld it, and it shows bias against the moving party, which is difficult to prove. Refusal to deliberate according to the law. Jurors must comply with the judge's instructions regarding following and applying the law as given, not considering any outside evidence, etc., or the court may declare a mistrial. Conducting experiments. Jurors should not conduct their own experiments which introduce extraneous information into the deliberations, but actual prejudice must be shown to warrant mistrial or reversal. Unauthorized visit to the crime scene. Next up, prejudice must be clear, such as when jurors were exposed to evidence not offered at trial. Intoxication. An intoxicated juror who is not physically or mentally capable of serving as a juror may be replaced with an alternate, or the judge may declare a mistrial. The intoxication must occur during trial, not during a weekend or overnight recess, to require mistrial or substitution of an alternate. Now let's go into some absolutely for sure unqualified misbehaving and biased jurors, okay? Just running through examples here of times when we have found that shit was wild. Okay, includes incompetent jurors, sleeping jurors, intoxicated jurors, racist jurors, and jurors with pending charges. In 1980, in Sullivan versus Fogg, a murder conviction was reversed and remanded because a juror was delusional and heard voices during the trial. The juror believed that the voices belonged to defense spies. Right. In State versus Majid in 2009, in Ohio, a capital murder case resulting in the sentence of term of years, plain error was found requiring reversal of the convictions due to extensive evidence on the record that at least one of the jurors slept through numerous portions of the trial, including eyewitness testimony. Quote, the numerous instances of jurors sleeping deprived the defendant of his right to have 12 attentive jurors decide his fate and violated his right to due process. It was apparently in 5 separate instances during the trial. It was brought to the court's attention that a juror had been fully sleeping, like passed the fuck out. Rather than admonish or remove the juror, the court responded on one occasion near the close of trial, quote, I saw it, so what? Let him sleep. You guys picked the jury. I didn't, end quote. And the Ohio Court of Appeal basically reversed that decision and said, no, you should have replaced them with an alternate or figured something out. In another case in Massachusetts in 2009, in Commonwealth versus Braun, a defendant in a drug case was denied a fair trial by trial court's failure to question a juror who appeared to have been sleeping through the trial. There you go. Judd versus State, 2007, another sleeping juror. Thompson versus State, 2004, sleeping juror. Earlston versus State, 2003, Florida, sleeping juror. People be falling the fuck asleep, which is like, okay, I kind of feel you. Sometimes it's fucking literally so it drones on and on and on. There's like 15 examples here. But look, stay awake, okay? Or like my thing is, if someone's not staying awake, alternates. Replace them with an alternate. That's what you gotta do. All right, intoxicated jurors. In People versus Hedgecock in California in 1990, an appellate court remanded to the trial court to exercise its discretion in determining whether to conduct an evidentiary hearing on defendants' allegations of jury misconduct, including a claim of excessive consumption of alcohol provided to the sequestered jurors by the bailiffs. That's crazy. Regarding that claim, the court stated, quote, according to the affidavit submitted by the defense, one of the bailiffs provided members of the jury with large quantities of alcohol, as a result of which one juror was unable to participate in the deliberations on the day the jury arrived at a verdict. Although jurors are under no duty to abstain from the use of alcoholic beverages when they are not deliberating, here the affidavits allege the consumption of alcohol rendered the juror unable to competently perform her duties, end quote. Also, the bailiff providing it to them is absolutely an outside influence exception. So I feel like this one was pretty obvious. You know what I mean? But damn. In 1889, you heard that right, in California, a capital conviction was reversed due to alcohol consumption during a break in deliberations for dinner. Although the jurors denied being intoxicated, the court stated, quote, we are of the opinion that where the proof of the drinking is clear and undisputed, and that it was done while the jury was actually deliberating upon the verdict, in a capital case, a verdict of conviction should not be allowed to stand. And apparently it came out later that they were like, could not even speak. They were slurring their words. It's not funny, but like, fuck. Next situation is too common. Too fucking common. It makes my stomach absolutely twist and turn horrendously. This section literally was split up by this author into like different types of cases. I mean, I'm scrolling. Oof, there's a lot. Racist jurors. The United States Supreme Court addressed this issue in Spencer versus Georgia. Justice Kennedy stated that he would have voted to grant the black death row inmate certiorari petition, which alleged an equal protection violation based on a juror's affidavit recounting the use of racial slurs concerning Spencer during deliberations and asserting that race played a role in the jury's verdicts. In Court of Appeals cases, in 2001, in Williams versus Price, the Ninth Circuit, so the Ninth Circuit includes what? It's like Alaska, Hawaii, California. Is it part of Nevada, Washington, Oregon, maybe a little bit of Arizona, I think? Look it up. There's a map. Where the petitioner claimed that a juror lied during voir dire when he denied harboring any racial bias, the state court unreasonably applied clearly established federal law by failing to consider testimony by a trial witness concerning a post-verdict encounter with the juror who allegedly uttered racial slurs. The case was remanded for an evidentiary hearing on the merits of the claim. In the Eighth Circuit in 1996, in United States versus Rouse, a new trial was ordered based on evidence of racial prejudice in the jury room. The court declared that racial prejudice in the jury room cannot and will not be tolerated or condoned. I agree with. Okay, fuck. Have more of that. In United States versus Heller, 11th Circuit in 1986, tax evasion conviction was reversed because jurors made anti-Semitic jokes and religious remarks. The court dismissed the jurors' denial that they were only joking, remarking that the bigotry in this case was reminiscent of a less civilized era. Jimenez versus Hayliger in the District of Puerto Rico in 1992, a medical malpractice verdict was reversed and remanded for a new trial because a security guard placed in charge of the jury stayed inside the deliberation room, brought jurors requested items related to the defendant's claim that he had not committed negligence. An additional ground of misconduct consisted of remarks an alternate juror made to a bailiff concerning the plaintiff's national origin, which indicated that other jurors had discussed her ethnicity and national origin. It was reversed and remanded for a new trial. Tobias versus Smith in New York in 1979, a habeas corpus petition requesting evidentiary hearing on jury misconduct was granted because of racist remarks, including one juror's remark that, quote, you can't tell one black from another. And a second juror admonished his fellow jurors not to accept the word of a black person over that of a white person. Ugh. Sickening. In People versus Estella in New York in 2009, overwhelming evidence did indeed support defendant's convictions for attempted murder, assault, and other charges, but defendant was nevertheless granted and entitled to a new trial, given a juror's post-trial statement to an assistant district attorney that the juror guessed that he based his decision on the defendant's race. The defendant was black and the juror was white. Although the juror later denied making that statement, the assistant district attorney was more credible than the juror, whose credibility was further weakened by platitudes such as, quote, half of my friends are black, and, quote, I voted for Obama. Right? Not doing you any fucking favors. Like, what the fuck? State versus Lofton in New Jersey in 2007. In a capital case, the conviction and death sentence were vacated during the early stages of the trial when it was learned that a white juror had told two of his black coworkers that he was going to, oh God, trigger warning. he was going to buy a rope to hang the black defendant who was charged with murdering a white man. This is in 2007. Sickening. When questioned by the trial court about the remark, the juror denied that he had predetermined defendant's guilt and he was permitted to sit with the other jurors for the remainder of the trial, which is obscene, although ultimately he was designated an alternate juror. At no time did the trial court voir dire the other jurors to confirm that the preconceived notions about defendant's guilt had not been conveyed to them. The New Jersey Supreme Court found that the trial court erred in not excusing the juror at issue immediately, given his apparent bias. It also criticized the trial court for failing to ensure that other members of the panel had not been irreparably tainted, period. It concluded that conviction and sentence could not stand because it, quote, had no confidence that the verdict was a product of a fair trial. Thank you. In Connecticut in 2007 in State versus Phillips, reversal of a verdict was based on the trial court's failure to investigate allegations of racist remarks made by juror to other jurors. Judge slept on the job. And all of these examples go on and on and on and on and on and on. Okay? Things like this happen all the time. I'm obviously reading from circumstances in which an outcome was I think, weighed in favor of justice, okay, and remedies for these fucking things. But oftentimes these aren't brought to the attention of the people that they need to be, and oftentimes they happen and the other jurors are tainted and shit goes wrong. And that, look, there are so many issues with our system, but having remedies in place where alternate jurors happen and also where voir dire is very, very pointed and very strategic, and also, you know, other jurors rat each other out. Fucking rat each other out, god damn it, someone else's life. Like, fuck, it's not yours. I mean, look, those are the safeguards we got. So do with that what you will. Now for the Ouija board jurors, okay, who are engaged in a tomfoolery never before seen, at least by me, probably before for sure. I can only imagine that in the 1800s, okay, they were absolutely getting into some dumb fucking shit, like on these juries. Can we be serious? The fact that I only read from one case that was from, what, like 1889 when they were all hammered drunk and they overturned the verdict. I mean, I'm sure they were like, let's pray about it. I'm sure they were having the dumbest fucking, like, prayer circle, like, friends, like, let's sing Kumbaya about it. Let's, like, you know, I don't know, close our eyes and everyone raise your hand. Like, I'm sure the way that they voted for these verdicts were so not okay. And it's not funny, right? It's all awful and horrible, and we can only hope that some evidence was fucking considered at the very goddamn least. But yeah, no, this is one where shit went awry, okay? And it was not in America, in America. It was actually in the UK, in the United Kingdom. So let's hear about it. In 1994, English insurance broker Stephen Young was found guilty of the gruesome double murder of Harry and Nicola Fuller. When the sentence came down, Sussex police detective Graham Hill believed justice had been served. The couple had been found dead on the floor of their home a year earlier, with Nicola shot 3 times and Harry shot in the back at close range. The lead investigator on the case, Mr. Hill, said the verdict, which followed a 5-week jury trial, marked the end of a difficult period. Quote, "There was relief the case was finished." He said, "Obviously, all people that are involved in the prosecution were pleased the verdict was one of guilty, because there's, as you can imagine, a huge amount of work that goes into that." End quote. 1 month after the trial had concluded, however, a front-page headline of the now defunct News of the World newspaper appeared out of nowhere and hit like a shot. Quote, "Murder jury's Ouija board verdict. Booze, dirty jokes, and then the Ouija board." God damn it. The report quoted the youngest member of the jury, 24-year-old Adrian, who said 4 jurors had tried to consult the spirits of the dead while locked overnight in Brighton's Old Ship Hotel. As the other jurors slept, the small group sat on the floor around a crude Ouija board they had made from a piece of paper and a hotel room wine glass. Now, let's back it up. If you are going to go into the supernatural and connect with a higher, lower, maybe, you know, around us power, you better have the real fucking novelty thing. I better see a receipt for this authentic ass Ouija board you got from a witch online from Etsy.com with the engravings, someone saged it. I want that shit to be authentic. You are fucking coming up with it literally off the cuff with a fucking wine glass and pieces of paper. Y'all, I know y'all don't have the credentials for that. Listen, look and listen. I'm doubtful here. I'm doubtful. And oh, if you're wondering, right? Oh, the wine glass, were they drink? Yes, they were drinking. This is after they were drinking, okay? Maybe not hammered, but like they were drinking, all right? Booze was involved. Come on, keep it tight. You know what I mean? Like if you're going to do something like this, at least pretend to be a professional. I don't know. Don't do it, but if you are, nah. They each put a finger on top of the glass and asked a spirit to guide the glass over letters of the alphabet and the words yes or no. One juror, Ray, took charge of addressing the spirit, which identified itself via the glass as Harry Fuller. I'm sure it did. Like, imagine being like, "I'll be me." You know what I mean? Like, they love the sound of my voice. Hey. Hey, king and queens up there. I would love to be the foreperson for the Ouija board. They all put their hands on the, if you don't know how a Ouija board works, okay, all of you, okay, separate people are putting your hands, like one hand or maybe two, on like a glass, and you ask a question and the glass moves. But in reality, right, like the idea is, oh, everyone's just moving it. You know what I mean? But like no one can really tell like, who can really be blamed for moving it. Whatever. Okay, I believe in some like spiritual shit, but the Ouija board for sure has some human goddamn error with it. Okay, I'm sorry, Lo siento. I'm sorry. Even people who don't believe in it are like, I won't touch it. I don't want to. I don't want to do that. White people typically want to, look for shit. All right, they want to explore the caves. They want to investigate the paranormal. I don't want to. I don't want to see it. Right? I'm running the other way. I'm good. I'm great. I'm good with not knowing. I'm good with not knowing. I'm good with not knowing. But in this case, it very much seemed like this was all a fucking sham. But who knows? So our boy Ray took charge, and the spirit spelled out the name Harry Fuller, and they were like, "Amazing, it's Harry. Hey, like, sorry about what happened. We're your jury. What's up?" Ray asked, "Who killed you?" The glass spelled out, "Stephen Young done it." He said, "How?" The glass spelled shot. As the jurors discussed what they should do, the glass spelled out, "Vote guilty tomorrow." Like, who was, but like, you know how long it takes? It's an alphabet. It's not like these words are laid out. Like, oh, we're discussing. Oh, look, it's moving. Guiltydomorrow. Oh my God, you guys, it's crazy. This is crazy work. By the end of the seance, some of the jurors were crying. A few jurors would say later they felt they had gone too far. The group retired to their rooms and agreed not to tell the others what they had just done. Just a few weeks later, their actions were causing controversy around the world. Graham Hill still remembers his disbelief when his neighbor passed him the newspaper front page over the garden fence. Probably your initial thought would be, well, it'll prove that it's a lot of old nonsense, he said. The headline was just the beginning of a case which would become one of the most high-profile examples of juror misbehavior in the world. Following the revelations in the News of the World newspaper, the UK Court of Appeal quashed the double murder conviction of Stephen Young and ordered a new trial. After another trial, okay, and mind you too, it's like juror misconduct, it's not just the defendants, of course, they're the ones affected, but like the amount of resources and time that's wasted and like manpower of all of these attorneys and all of these people and all of these court officers, how much time and money and effort and brain power it takes to run a trial and to put on evidence and all the witnesses who testified and all of the people who testified with respect to the evidence and the blood spatter and the bodies, and it's just like, are you fucking kidding? Like, we have to do this again, and even if the decision's right in the sense that yes, the UK court was like, nope, like you need a new trial, fuck that noise, like what the fuck was that wine glass little spirit thing you did? That's cute. No, it's like now we have to have new jurors. It's like, you know what I mean? Like, be fucking serious. Like, be serious. And it's a fucking, like, do you want the victims too? Holy shit, do you think that they want another trial? No, they don't. They want a verdict to stand. We need the finality, people. Don't fuck around and find out. Stop it. Stop it. After a 5-week hearing in December 1994, okay, so the second 5-week trial happened, the jury again found Stephen Young guilty. Okay, new jury, right? So he was guilty twice, which is tough. Which is tough to beat. Responding to the Court of Appeal's decision, Nicola Fuller's father said the Ouija jurors, quote, made a complete joke of our daughter's death, which I agree with. Like, fuck you. I'm sorry. That's so disrespectful and so disgusting. And I mean, look, yes, serving on juries is really difficult, especially when very, very horrifying evidence you have to listen to, right? And no one else in the world has seen except for the law enforcement officers and the attorneys and the people in that courtroom. I mean, there are things that there are things that people who have served on a jury have to go to therapy over. They have PTSD over hearing. I mean, it's horrifying. It's terrible. It absolutely doesn't, like it's not okay, toughen up. This is what happens. But I mean, to to say, and they do ask you questions about that too, you know, like they don't want to fucking chain somebody to a chair and force them to see things that they can't even rationalize in their own head. The people on the jury absolutely do. They're doing a duty and their civic duty, and they absolutely are very brave for doing a lot of this stuff. And being able to objectively look at everything, look at the evidence, and make a decision based on the law and based on, you know, the standard for beyond a reasonable doubt is admirable. And it's really difficult to do, but again, like someone has to do it. Someone has to do it. And if it's going to be you, don't make a mockery of the victim's death by not trying to get it right. Like, this was obscene. This was beat. Decades after his involvement with the investigation, Graham Hill, one of the investigators, said he agreed with this statement. Quote, "I think it was, I'm using the word stupid, but it's far worse than that. This is making an absolute mockery, and it's the most serious trial you can ever have. There is no element of humor in it at all. There's no frivolity in it at all, and yet those 4 members of the jury made it into a laughingstock." However, a lot of legal scholars, including in the UK and around the world, say juror misbehavior will inevitably occur. And this case, although it was unexpected with respect to the tabloid coverage, it's not necessarily exceptional. Okay, it's not the first of its kind. For example, there were plenty of other cases that year in the UK where jurors were reported to have done somewhat odd things: falling asleep, giggling, grimacing, falling in love with a lawyer, a barrister. Okay. And the court just in each case said, quote, "That's the jury system for you. It's a little bit crazy." My rebuttal for today's episode is that if you are going to serve on a jury, leave the cocaine, the weed, and the alcohol at home, maybe a martini at night if you really need it. But if you are getting hammered drunk with your new homies at noon on the lunch break, don't do that. Don't do it. And if you see other jurors doing it, please report it, because these are people's lives at stake. Although it's really funny to talk about, it's not funny. Stop that. I just wanted to say that I appreciate all of you more than I can even bear to express. I know that, I hope that I remind you guys a lot of how much I adore your presence and your commentary and your just light and space that you hold online and with me and in my DMs and in my messages and in my email and in my likes and in my follows and in my comments everywhere. It truly is such a special place in my heart that I have for all of you, and for you guys to endlessly support me and to laugh along with me and to give a shit and to listen is just beyond anything I could have ever hoped and imagined and dreamed of. And I know there are a lot of silent watchers and listeners out there, and I just want all of you to know that I appreciate you, and I do not take anything that you do for me for granted, whether it be just, you know, supporting my stuff, or whether it be you know, sending me words of encouragement all the time, or comments all the time. Like, I see them and I love them and I adore them. And it's just, I couldn't be any luckier, and there are so many other people who deserve to receive that kind of love every day, especially in that field. And I'm just blessed that y'all have seen something in me. So yeah, thank you, and I'll see you next time. Love you.